Thank the gentleman. We now go to the ranking member of the full committee, Mr. Nadler, for 5 minutes.
Thank you, Mr. Chair. Mr. Cohen, there are a lot of reasons why some of us favor non-compete agreements. What would you, but I understand the concern about China. What would you think about if we were to pass a national non-compete agreements, but say that it doesn't apply to Chinese companies?
Yeah, I think and my conflicts of law teacher would say you would have a renvoi provision, that is that you would let it be governed by foreign law. I mean, China has its own restrictions on non-compete agreements, and I think if you left it up to companies to draft non-compete agreements that comply with foreign law, that would be a solution to addressing the problem of poaching of trade secrets by foreign companies of U.S. technology. So that could apply to any country in the world. It doesn't necessarily need to only apply to China.
So you think it's a good idea?
I think that's a good idea. I think actually that would be a good provision for California to add on to its existing ban on non-compete agreements, that a non-compete agreement would be enforceable in an international context. And frankly, before the FTC came up with that proposal, I was trying to develop some momentum to amend the California law.
Thank you. Mr. Duan's written testimony makes a point of noting the low quality of Chinese-owned patents, while Mr. Cohen's testimony cites research suggesting that China is currently the world leader compared to the United States in 37 out of 44 advanced areas of technology. I find it difficult to reconcile these two statements, and in particular, I'm concerned that we are unwittingly blinding ourselves to appreciating how serious our competition with China already is. Mr. Cohen and Mr. Duan, would you like to comment on this? First, Mr. Cohen.
Well, I think we have blinded ourselves for over 20 years in not dealing with the technological threats that China presents. And if we had time, I could go through my own horror stories as a U.S. government official, where I have tried to get American agencies to recognize that trade secret protection is enormously important, technology licensing is enormously important, patent protection, plant variety protection, all the technological areas of intellectual property need to be front and center. China always had a goal of regaining its historic Industrial Revolution era supremacy in technology. This is nothing new. What is sad is that we did not recognize China's emerging competitive edge in so many areas, through legitimate practices and less legitimate practices of the type we've just heard from. And I think this really calls for a rethink in the U.S. government, not only of what went wrong, but more importantly, how we can come up with better strategic decisions that are based on facts, that anticipate existing and likely future challenges.
Thank you, Mr. Duan.
Yeah, I think the first part of answering that question is distinguishing between patents and innovation. Right? It's possible to file a patent application on a very simple technology, one that doesn't really push the boundaries. And what we've seen from a lot of Chinese patent applications and patents is that because of the subsidies that China has provided, because of the quotas that China has used, China has encouraged the filing of a lot of patent applications, but often ones that are of these sorts of low quality. The petty patents that China offers that require less examination, provide less protection, and don't really demonstrate the sort of innovative capacity that a full-fledged US patent would provide. Now, that's not to say that those patents are useless. In fact, we have examples from American law history in which a flood of low-quality patents ended up getting into the hands of entities that were often shady and we couldn't figure out what was going on with them, becoming tools in which companies could assert them against small startups, against small businesses, preventing Main Street restaurants from putting putting electronic menu displays up, things like that. So that's where I would be concerned that even though there are lots of low-quality patents, they might turn into these problematic tools.
Thank you, Mr. Cohen. A basic premise of the treaties governing IP to which the U.S. and China belong, the TRIPS agreement, is that foreign entities will have the same access to patenting and court enforcement of those patents as nationals. According to your testimony, however, it seems that U.S. companies as well as other non-Chinese companies are not availing themselves of the Chinese court system to enforce their patents much at all. In other words, it seems that we are de facto not getting the benefit of the bargain anticipating the agreement. Do you agree with this? And if so, how would you recommend we consider responding?
Well, I agree with the statement, and I think this points to a problem that is little talked about, which is low utilization of the Chinese IP system by foreigners. Now, this may be because some foreigners are frustrated They have a lack of confidence in the system. When you try to take the low utilization rate and also compare it to the high success rate, it's a dilemma that's very hard to resolve. In some areas, like software piracy, Microsoft, for example, according to published data, has had a 100% success rate in litigating software piracy cases, as have most of the other large software companies. In patent litigation, numerous studies show that foreigners win at a higher rate than Chinese litigants in patent infringement cases, that they are more likely to get higher damages, and that they're more likely also to get injunctive relief. In one case, actually, the Beijing High Court, for 1 year, the success rate at that important court for foreigners litigating IP cases of all types was 100%. So how do we explain low utilization? I think part of it is also attributable to the fact that many foreign companies view IP litigation as not so much a legal act, but a political act. There's a cost. They're going to have to lobby the Chinese government. They may have to lobby the US government. There may be a public relations cost. And when they put all those things together, they end up backing away from the Chinese IP system. But I have to point out one other thing, which is that litigation, whether successful or a failure in China, is a critical source of information for the kinds of discussions we're having today. If you cannot sue the Chinese government or a state-owned enterprise, for example, for IP infringement, that is important information for us to know as we think about the proper policy going forward.
Thank you. My time is well expired, and I yield back.